they're in DC.
And Womack, are we ready? Okay, it's 2 o'clock. If you would, please, Ms. Womack, please call the roll. Oh, Julie? That's right, Julie. Julie, would you please call the roll?
Please.
Somebody called the roll.
Yeah, somebody. Would everybody raise their hand who is present?
That would be a very simple way to do it, but we will call the roll. Commissioner Dewey,
Here.
Commissioner Ellison,
Here.
Commissioner Hunter,
Here.
Commissioner Stewart. Here. I know that Commissioners Stockdale and Strange are not here. Commissioner Bryan,
Here.
Commissioner Davis here.
Thank you.
And me? You didn't call me?
Oh, Susan,
Here.
how did I leave you off the list?
Sorry.
Sorry.
I'm here.
All right, I declare this meeting in order. The first thing would be any correspondence, Ms. Womack? No. And as far as verification of meeting notice, and would you please take care of that for a real change of agenda? We normally do that at the end because I forget.
The agenda for the planning commission regular meeting was posted in City Hall and on the city portal on December 1st, and was sent out from the portal the same day. The agenda was amended and reposted in City Hall and on the city portal on December 2nd and December 8th, and resent out from the portal on those same days.
Thank you. Thank you. We have 3 sets of minutes to approve, please, to consider. Special meeting January 15th, regular meetings on September 9th and October 14th.
I will abstain because I was not part of the planning commission. on those
All right.
dates.
Let's start with the meetings on meeting on January 5th, 2022. Are there any revisions, changes?
Mr. Chairman, I show that that is January 5th,
Oh, I
not the
apologize.
15th. I think that's just a typo in the agenda.
It all depends on which set of glasses I have on.
No, it says 15 in the agenda.
That was a typo in the agenda.
All right. Are there any revisions to that date? All in favor?
Aye.
Aye.
All opposed? All right, the January 2022 minutes are
Chairman,
approved. Yes.
I'm also abstaining because I was not present.
Okay, thank you very much. We'll go next to, we'll go to the September 9th meeting. I would ask one consideration, at the bottom of the first page, the very last line, no oral argument has been either set or scheduled, whichever. And then on the second page, report of new applications that may have been previously submitted. It might be helpful if we identified which project that was for. I'm sure that's the Rehoboth 1 project, but that's all.
Say no, there are none. Does that set of minutes say there are none?
No, it says an application has been submitted for concept review, but it didn't say which project. Yeah. Anyone else? Counselor?
I don't vote, but I do have some suggested changes to your minutes for that. For September 9, I was present, so you may want to include my presence, since I think I was the one being quoted. Top of page 2, third line down, later this month, one of those thises should come out. Under new business, third full paragraph, 1, 2, 3, 4, 5, 6, 7 lines down, on his own and, go ahead and handle on his own and issue, just issue, no, not issues, just issue building permits on. Those are my only additional suggested changes.
Anyone else have any changes? Ms.
Well,
Davis?
I just want to note that I was absent on both September 9th and October 14th.
Okay. Susan?
Two.
Okay.
Yes.
No.
All right. Anything else for that particular meeting? All in favor of the
Aye.
September 9th meeting? As amended?
Aye.
Aye.
Any opposed? Okay, those minutes are approved. And then last but not least is October 14th, 2022. Anyone have any revisions to that one or amendments? Hearing none. All in favor?
Aye.
Opposed? All right.
Is there a maker of the motion?
I'm sorry?
A maker of the motion? And a second?
I so move.
And do we have a second? Would that be to approve all three as amended?
Yes.
Second.
All right. All those in favor?
Aye.
Aye.
All those opposed? All right. Those minutes are approved. I guess the next thing at this point would be the discussion and possible vote on amendments to the Planning Commission bylaws and rules of procedure. Mr. Mehta?
Okay, so these are topics that have been on the agendas of prior planning commission meetings for the past several months. I thought what I would do would start by just providing some context for proposed rules and bylaws changes, and then go through the proposed bylaws and rules changes, and then we can switch over to the proposed code changes, which is upon a referral from the mayor and commissioners to specifically recommend proposed code changes regarding site plan review. If I am able to do this through technology here, I should be able to put on the screen for everybody to see a red line document. Will start with the proposed bylaws and rules. But first, as I said, let me provide some context with regard to rules and bylaws. Like any public body, the Rehoboth Beach Planning Commission may promulgate its own bylaws and rules, and therefore might amend as appropriate its own bylaws and rules. These are your bylaws and rules. They're not mine. I don't vote. My job here is simply to facilitate your discussion and to help you draft any changes that you want to make by vote. There is language both in the existing bylaws and your rules as to the process for amending both. You certainly have had this language from me as proposed language for a while, though there's not been any public debate on these rules until today, as required. Before I get into the specific language for the proposed bylaws and rules, let me just provide some context for you, as it might be helpful. One, with regard to the rules, you may want to clarify the scope of the rules. Do you want these rules of procedure to apply only to proceedings under Chapter 236 of the Code, or do you want these rules to also apply to your deliberations the next time you modify or consider the comprehensive development plan, for example? You have a lot of meetings. You have meetings basically once a month, but not all of them have to do with Chapter 236 proceedings. So the scope of proceedings, you may want to clarify what the scope of the rules are in respect to particular proceedings. Another example, in addition to the CDP, is one of the matters we're going to take up today. A referral from the mayor and commissioners is not a Chapter 236 proceeding. To the extent that you want your rules to apply or not to matters or meetings other than Chapter 236 proceedings, you may want to consider that. And we'll get into the specific language here in a minute. Second contextual point, you may want to consider amending deadlines for applicants or site plan submissions or members of the public to submit written materials for your consideration at a particular meeting. Third, there is a proposal to establish a new rule, which would be basically a disclosure requirement that if a subdivision plan or a site plan is before the Planning Commission, if there are any other past, present, or future submissions or requests by that applicant to any other body in the city, that the applicant is aware of, that should also be disclosed to the planning commission. So let's say there's a site plan before the planning commission that is also contingent, for example, on getting a variance. This proposed rule would require that the variance request also be submitted to the planning commission. The idea here is just to have a robust disclosure, so the planning commission has at its information, or at its disposal, I should say, all relevant information. There's a proposal that for your consideration that you may want to consider amending your recusal rules. The recusal rule that you have right now is different than the state code of conduct rules. You may want to consider amending that. Those are as a context for the rules. That one context point for the bylaws, which we'll talk about here in a second, is whether you want to be bound by the hundreds of pages of Robert's Rules of Order, or whether you simply want to use Robert's Rules of Order as a guide and reference point. So with that context, I'll direct your attention to the red line document. Again, just to explain here, the black language is existing language. The underlined red language is proposed new language, and the stricken red language is obviously proposed to be deleted. So these are the bylaws, the proposed, for your consideration, the proposed amendment to your bylaws is to delete current paragraph 10 or section 10 of your bylaws and replace that with this new language. So strike Robert's Rules of Order are hereby adopted for the governance of the Planning Commission in all cases not otherwise provided for in the Planning Commission's Rules of Procedure. Proposals to strike that and insert in lieu thereof the following language. The chairperson or the chairperson's absence, the vice chairperson is responsible for presiding over any Planning Commission meeting or hearing in an orderly manner consistent with the city code, these bylaws, and the Planning Commission's Rules of Procedure. In doing so, the chairperson or vice chairperson may consult Robert's Rules of Order for guidance and reference, but Robert's Rules of Order shall not be construed as establishing any substantive or procedural rights or privileges for any member of the Planning Commission, any applicant, or any other entity. The other proposed modification or amendment to your bylaws is in Chapter 14, which I alluded to earlier, to insert the following new language in Section 14, I should say, of the bylaws. Members of the Planning Commission shall abide by the Delaware Code, Title 29, Chapter 58 of the Delaware Code, which is the Delaware Code of Conduct, whereas may be subsequently modified to the extent applicable when determining whether they should or must recuse themselves from participating in or voting on any matter that may come before the Planning Commission. The State Code of Conduct, as interpreted by the Public Integrity Commission, or KIP, PIC, has quite a few opinions out there that construe the State Code of Conduct, whereas the language that you previously have had in your rules for recusal has, as far as I know, zero language interpreting what it means. And this might just be a more transparent standard for both you and for the public, quite frankly, to follow on matters of requested recusal.
All right. This is a matter of discussion before we consider whether to vote. I'd like to open up the floor for anyone to make comments that they may have to what's being proposed here, and then ask as well, is there any other additions, changes, modifications, amendments, whatever? Ms. Hunter.
Thank you, Mike. First, I would say that I support the two changes that appear in Luke's draft, but I have one more. I want to suggest one more change, and I want to start actually by recognizing and acknowledging our recording secretary, Ann Womack, who has done such an incredible job in terms of producing minutes for all of us. And probably a job that may belong to more than one person. So what I would suggest is an amendment to Bylaw 6C that would add a subsection of, I guess it's triple small I, giving the secretary, who's one of the officers of the commission, the responsibility for reviewing the minutes drafted by the recording secretary, suggesting or proposing any necessary edits, and then circulating to the planning commission for adoption. So this would, in essence, place upon our officer the responsibility for that aspect of the secretary's job.
Any discussion on this proposal? Well, first let me ask, does anyone have any other suggestions, comments about what has been proposed here, the ones that our council reviewed? Anything else to those? And then we have Ms. Hunter's suggested addition. Any comments about that, please, for or against? We've deferred this item for some time, so I think it's important to get it looked after when our agenda is such that we can do it.
We're going to vote on these separately, this plus the procedures separately, or are we going to?
Let's vote on what we
together?
have before us
Okay.
separately, and then see if we can move forward that way. Is there a motion to approve what's been proposed here today?
So moved.
Second?
I'll second.
All in favor? Any discussion? All in favor, say aye.
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 Opposed? All right, these are approved. Mr. Mehta.
Okay, then moving on, so those were the bylaws. Now moving on to your rules, which are currently in attachment B to your bylaws. Again, I've already laid out the context, so here I'll just go through the proposed actual language. The red line insert in the preamble adds the following proposed language. These rules of procedure shall apply to meetings and hearings of the Planning Commission to consider matters under Chapter 236 of the City Code. With regard to meetings and hearings of the Planning Commission, consider matters other than under Chapter 236 of the Code, such as updates to the Comprehensive Development Plan, referrals from the Board of Commissioners, or other matters. The Planning Commission reserves the right to adopt specific additional rules of procedure for such matters and or incorporate by reference expressly some or all of these procedural rules, provided that where the Board of Commissioners has referred a specific matter to the Planning Commission, the Planning Commission's ensuing recommendation shall be reflected in a written report or resolution. So that is new language in the preamble that addresses the first point about scope. Under Section 1, it's pretty obvious, just to clarify that these rules, the new language here is these rules supersede any other rules previously adopted by the Planning Commission. There's a proposal to reword paragraph 4, acceptance of written testimony from a member of the public, to state as follows. Public participation during public meetings and public hearings. Let me just provide some context here. The state FOIA, Freedom of Information Act, establishes the bare minimum requirement for public participation. The city code adds some additional provisions regarding public participation, particularly during public meetings or public hearings. And third, of course, this body can, in its discretion, invite even additional public participation beyond which is otherwise required by FOIA or by the city code. And so that's what this proposed language attempts to do and clarify. So the proposed language is as follows: unless required by Delaware's Freedom of Information Act or the city code, for example, with regard to public hearings, comments and or testimony by members of the public during or in connection with a public meeting of the Planning Commission under the city code shall be permitted only in the discretion of the chairperson of the Planning Commission, but not as a matter of right. Again, this is only if otherwise not required by FOIA or the city code. Continuing on, if any member of the public wishes the Planning Commission to consider any written materials or testimony at a public meeting or public hearing, That person must submit such written material or register to testify in advance of the hearing or meeting by the deadline set by the chairperson. The chairperson is authorized to set deadlines for submission of written materials and for registering to present testimony in advance of a public hearing or meeting, to set time limits for oral testimony in a hearing or public comments at a meeting, to continue a public hearing to a specific date or specified date, and to leave a public hearing record open to receive additional written materials and/or allow members of the commission to consider and review the review the record prior to voting on the matter that is the subject of the public hearing. This language reflects reality in the manner this commission has conducted itself in the past. It contains language which you will find throughout many other public bodies' rules of procedure. This is not unique language. It simply empowers the chair to require some advance submission of either written or proposed oral testimony. That's paragraph 4. Paragraph 5 seeks to clarify how a chair may want to conduct a hearing or a meeting when members of an applicant, or either an applicant's representative or members of the public, are either presenting oral argument or perhaps cross-examining a witness. So you can see what the proposed new language is and what the stricken language is. I'll just read the proposed rule as to be rewritten as follows. Testimony or comments shall be directed to the Planning Commission. During meetings and hearings of the Planning Commission, applicants, their representatives, and members of the public shall direct their testimony or comments only to the Planning Commission and not to city staff, members of the public, or applicants' representatives in attendance. Questions by members of the public, an applicant and/or an applicant's representative during or in connection with any meeting or public hearing of the Planning Commission shall be permitted only in the discretion of the chairperson or acting chairperson of the Planning Commission, but not as a matter of right. Members of the Planning Commission are not obliged to answer any such question posed. Any witness presenting factual testimony rather than legal argument to the Planning Commission must either swear or affirm under oath that the factual testimony presented or to be presented is truthful.
Excuse me, are we going to, point of order, are we going to discuss these as we go through them?
We can do it any way that you choose. If that's more convenient, we can certainly do that.
I think it makes more sense to, if there are questions.
Okay.
About, because I support the revisions so far, rules 1 through 4, but I do have a question about the last sentence in the amendment to Rule 5, and that is simply that I think it's perhaps difficult for us or witnesses or anyone to know whether a witness is going to present factual testimony or legal argument. I mean, obviously, sometimes it's quite clear, but I think for persons who are, especially persons who are not lawyers, it may be a problem. So I wonder if that last sentence could say something like, and I can give this to you later, but any witness presenting testimony to the Planning Commission must either swear or affirm under oath that the factual assertions presented or to be presented are truthful and accurate to the full extent of that person's knowledge.
So would we then, in order to address that issue, would we have to put anyone who speaks under oath?
I believe so. I think if we're going to go in the direction of putting people under oath with regard to their factual assertions, I think it makes, that I think will be the more common context, rather than having persons who present only legal arguments, even with respect to lawyers. So I just think
Well,
I
you may
ca-
want to put the lawyers under oath for sure.
Yes, yes, swear all the lawyers first, to paraphrase Shakespeare, right?
Kill them.
After you kill them, yeah. Uh, Yes, so that would require that, but rather than have someone say in all sincerity, I don't, I'm not exactly sure what I'm gonna say which part falls into law and which part falls into fact. I think it's just simpler to put everybody under oath if we're gonna do that at all.
Mr. Mehta, point of order, who basically would administer the oath? In Virginia, it's usually the clerk of court or some other official. but
Typically,
Notary.
it could be the presiding officer that is the chairperson or acting chairperson. I've seen the lawyer do it. I've seen the secretary clerk do it. I think it could be anybody. I will say, Ms. Hunter, I think if you applied this to a Delaware lawyer would state that under Delaware law, a Delaware lawyer does not have to be take an oath with regard to, unless they are testifying. Now, they're testifying, they do, but if they are simply presenting oral argument, I think any Delaware lawyer here would resist that.
Well, but excuse me, that is how this would read, as I understand it. It would be any witness presenting testimony.
Testimony as opposed to
which
argument.
is not oral argument.
Correct.
And for what it's worth, my experience with several other jurisdictions is that witnesses, whether they're lawyers or fact witnesses or property owners, whatever, are routinely sworn in without any distinction made as to whether their testimony relates to either facts or law. It's just, as a matter of course, they're sworn in.
Without getting into it too much, a Delaware lawyer would say, I'm bound by the rules of professional conduct. I do not need to be sworn in.
Well, I leave that to.
But
the
certainly,
Delaware
you don't need to
lawyers.
swear somebody in to present oral argument.
No, of course
But
not,
we're
but,
not talking about oral argument.
yeah.
Right.
And really, I think, Ms. Hunter, your proposal limits, the oath really then only goes to factual assertions.
That's correct. It doesn't make any,
Argument is not part of that.
right, it doesn't make any distinction about who is making the statements, but it does make the distinction between certifying that if you're going to make a factual assertion, you're certifying that it's true. And you make a legal argument or an opinion argument or something else, then that's different.
Okay. Any other thoughts about that? Could we perhaps, is this an appropriate time to approve up to where we
wherever you wanna
are
do it.
and then move forward and deal with the rest? I believe, I did not hear any objections to anything up through paragraph 5. And paragraph 5 is the one that Ms. Hunter is amending. So could I have a motion to approve these changes up through paragraph 5
So moved.
as amended? Second?
Second.
All in favor?
Aye.
Any opposed? All right, these are approved up through paragraph 5.
Okay,
Counselor.
And can I just clarify, I apologize for going back, but just to make absolutely sure, when we approve the bylaws, we approve those with my amendment, is that correct? Okay, thank you.
Then, moving on, there are just some minor clarifications in paragraph 6, simply adding in section 6 of the, these are the rules here, not the bylaws, under the third bullet adding, and fourth bullet adding the word subdivision before application, since that's what we're talking about here. Same thing with the next bullet. I don't know if you want to take a vote on that, or if you want to keep going.
Keep going.
All right, let's go to the next one, where there's nothing, I don't think, in 7. 8, some minor changes for paragraph 8. Agenda, applicants for subdivisions or site plan review will be considered in the order of their submission and in accordance with the provisions of Chapter 236 of the City Code as determined by the chairperson, given the matters then pending before the Planning Commission.
Any comments about that? Any suggestions, changes, amendments? Okay, let's move on.
Paragraph 9, this is some minor changes to the paragraph regarding order of consideration of subdivision or site plan review applications. The following procedure, this is again repeating existing language, the following procedure will normally be observed, however, it may be rearranged by the chairperson for individual items if necessary for the expeditious conduct of business, modifying the second bullet to say questions from the Planning Commission regarding the staff presentation. Fourth bullet, presentation, comments, and or questions, insert as appropriate by interested citizens. 3 bullets after that, consideration by the Planning Commission of the agenda item. That's the extent of changes to paragraph or section 9.
Any comments there? Okay, continue, please.
Section 10 is simply changing, just putting in caps the intro for conformity, same with 11. 12, this is, goes to the point we talked about earlier regarding deadlines for the submission of written materials by applicants. So I'll just read the proposed language for paragraph 12 or section 12. An applicant must submit all written materials in connection with an application to the Planning Commission at least 28 days prior to any meeting or hearing at which the Planning Commission is asked to consider an application, provided that, in the discretion of the chairperson may allow an applicant to supplement such written materials by a deadline set by the chair. In the absence of an affirmative waiver of this requirement by a majority of the Planning Commission will not consider at such meeting written materials submitted after such date. So this provides an out for the chairperson and the commission by the majority vote to allow truncation of the 28-day period.
I have a question.
Yes.
As far as the 28 days prior, that was changed to 30 days, and that went through a commissioners meeting.
Was that applicable only to the commissioners?
No,
Or is that city code?
Yeah.
Mr. Counselor, do we have any issue with taking that to 30 days?
No, it's up to you. It's your,
I think
these are
that's-
your rules, not mine. But it should be consistent if that's what the modification is.
I would support that. This, in my experience on the commission, addresses an issue that we had during the clear space matter, and I'm very much a proponent of this, and 30 days seems reasonable to me. Anybody else have any opinions, though? Any discussion about that? All right, then we are good up through section 12, is that correct?
Well, let's have the vote on accepting, right?
Up through 12?
Yeah.
All right, do I have a motion to approve revisions up through section 12?
So moved.
Second?
Second.
Any discussion? All in favor?
Aye.
Aye.
All opposed? All right, it is approved. Mr. Counselor?
Moving on to section 13. This, again, is the language I alluded to earlier in the contextual discussion. New proposed language. It's a new language. Disclosure of other submissions regarding same property. In connection with any application under Chapter 236 of the City Code submitted to the Planning Commission for its consideration, an applicant shall disclose to the Planning Commission any and all pending or contemplated submissions or requests by the applicant to the Planning Commission or any other city board, commission, or committee regarding the same property, including but not limited to variance requests, rezoning requests, and appeals, as well as any such submissions or requests known by the applicant to have been made by any person or entity within the previous 2 years.
Any comments?
I have one.
Concerns? Ms. Davis?
In paragraph 14, we have added to variances and rezonings, or it's been proposed, other authorizations under applicable federal, state, county, or city laws and regulations. I see no reason why that phrase shouldn't be in paragraph 13 also, because if such other governmental authorizations and approvals are going to be necessary and the applicant knows about them, then I think they should be disclosed also. And that would make paragraph 13 consistent with paragraph 14.
That seems logical, but anybody else? All right. Let's go ahead and look at 14 at the same time and then talk about approval.
Okay. Now, 14, this is language proposed for your rules, as to which you will see proposed parallel language in the proposed code recommended changes in respect of site plan review. And it really relates to what you may refer to as the sequencing. What comes first? A submission to the Planning Commission for site plan review, for example, or a rezoning or variance request. Variance request going to the Board of Adjustment, rezoning request going to, presumably, the Board of Commissioners. So this is language that attempts to set forth in your rules, and again, we'll take it up separately in the proposed code language, the sequencing of these various requests of government action in the form of the city of Rehoboth Beach. So here's the proposed language. One other thing, and let me just so everybody understands. So the proposed new language is in red, underlined. What I've attempted to do, perhaps not very artfully, is add in red italics alternative proposed language. That is, these aren't my rules. I'm not trying to tell you to do anything. I'm just trying to facilitate a discussion. And so the italicized language is proposed alternate language that you may consider. There may be 3 or 4 or 5 other alternate proposed phrases that you want to add. So here's the proposed language with its alternate language. Sequencing of related variance and rezoning requests. The Planning Commission shall defer, or alternate language would be, or shall have the discretion to defer, a preliminary review of, or a public hearing or final action on, a site plan for which a variance, rezoning, the alternate language would be, and or other authorization under applicable federal, state, county, or city laws and regulations, which is language borrowed, taken directly out of 23630E of the existing code, is required until such time as the variance, rezoning, the alternate language would be, and or other government authorizations, is obtained, and then the other alternate language is, and becomes final and non-applicable to any judicial, administrative, governmental, or regulatory body. Let me do this again. Let me read one proposed language, and I'll read the other proposed, the alternate language. Proposal 1 would be, the Planning Commission shall defer a preliminary review or a public hearing or final action on a site plan for which a variance, rezoning is required until such time as the variance or rezoning is obtained. Another way of approaching it would be the broader approach. The Planning Commission, or some variant thereof, the Planning Commission shall defer, strike that. The Planning Commission shall have the discretion to defer a preliminary review of or a public hearing or final action on a site plan for which a variance, rezoning, and or other authorization under applicable federal, state, county, or city laws and regulations is required until such time as the variance, rezoning, and or other government authorization is obtained and becomes final and non-appealable to any judicial, administrative, governmental, or other regulatory body.
All right.
Yeah, I have a question. First of all, I'm glad to see this language in there, but I'm wondering now, I'm almost thinking that in the first line, we may want to insert the discretion. The reason being that in the 2 site plans on record that have been approved, namely the Avenue Inn and the elementary school, those actually went through preliminary review, and it was determined during preliminary review that the variance would be needed. They then got the variance and came back for final review. So since that is our history, I mean, it certainly seems possible that for any application that comes, we wouldn't see some of those issues until preliminary review. I suppose if we do see them before preliminary review, then we would want to defer. Absolutely, we would want to defer. But if we didn't see them before preliminary review, so I'm wondering if the discretion should be there to cover those issues.
Anyone else?
It would seem to me that if in the process of preliminary review, I mean, if it wasn't known prior to the preliminary review, that there was another authorization that was required, then what happened in the past would be exactly what would happen in the future. I mean, I don't understand. I mean, the question would be then, in that situation, if preliminary review is sought, and in that process it becomes apparent that another authorization is required, would the Planning Commission at that point defer until the other thing is obtained?
Yes.
Or would it just,
Discretion.
Yeah, that's what I'm thinking. That's what I like. I like the fact that it covers all of our steps: preliminary review, public hearing, final action, and it gives us the discretion to halt at any point, should a variance be needed, right?
Well, but it doesn't cover concept review,
It doesn't.
which I believe is in the proposed or the code changes that we're going to be considering. And what this says to me is that if it's clear, the applicant knows, building inspector has identified, we all know, for whatever reason, the variance or rezoning or some other governmental action, such as a FEMA permit or DENREC or whatever is going to be necessary, then the chair has the absolute, I mean, we're just going to defer it. If during preliminary review it becomes apparent that more is needed, then more is going to be needed before you get final approval. But I'm not sure. My problem with making things discretionary is that in the absence of standards for determining what the discretionary action has to be based on, sometimes that can present legal issues in and of itself.
I'm fine with that as long as we have the option to, as long as we don't have to make a decision up front and then never revisit it. I mean, we have the option throughout the process to defer. Is that the way you would read it?
Can you give me a more specific, I'm sorry.
Well, if something comes up, if there are no variances disclosed, none planned, but in preliminary review, something comes out that it looks like, oh, they are going to need this small little variance for something. Can we at that point say, well, in that case, we will defer public hearing and final review until that's obtained?
Well, certainly we can talk about the language. The preliminary review section of the code specifically talks about if there are matters that have come up that require. And then, of course, if it were to come up at a very, very, very late stage, I have to be careful what I say here, but among the options that might be possible for the Planning Commission would be to reject an application because there's no code compliance, or to approve it on the condition that a variance is obtained.
Okay.
you know, I wonder if it's possible to reword it, which I can't do off the top of my head, to clarify what would happen in the situation that Susan Gay has stated. Just because, I mean, I think the idea behind having a shall defer is that otherwise the implicit invitation is for preliminary review applicants to say, please exercise your discretion and just go ahead, even though
I
we
get
know.
that makes sense.
So
Yeah.
I think maybe we're agreed on what we want to come out of this. Certainly, if it comes up, if nobody knows, or it isn't apparent, whatever, then yes, at that point, the Planning Commission, I think, should defer, should you know, sort of table it almost.
Yeah, well, as long as it preserves our right to do that at any step in the process, which I guess was really my question.
Yeah, I think that's a good question, but, and again, I can't do it off the top of my head, but maybe there's a way to reword it so that it makes that more clear.
I mean, do we add a sentence perhaps that talks about the right to defer while something is pending? I'm just throwing that out. I mean, I hear what everyone's saying.
Yeah. I think it would merit, you know, sort of coming back with a second proposal for language.
And to add to that, I think, because to me, it's sort of, this presumes before the preliminary review starts, there's a deferral or a discretionary deferral, but it doesn't talk about mid-preliminary reviews, diversion, and that's what you're talking about. Because otherwise, once you start the preliminary review, you've already started the preliminary review.
That was my point, yeah. That
Right.
was my question, yeah.
Yeah, but I think that's the discussion that Ms. Gay
Right.
and I were just having.
Right.
There are already provisions in the code regarding your flexibility
Within
at the
that.
conclusion of a preliminary review.
And we'll be getting to that when we talk about that today, right? We'll be
Yes,
getting
we
to that
will.
today, so.
The other thing, just, and I can't stress this enough, is when we get to the proposed code language, you don't vote, you make a recommendation to the Board of Commissioners. The Board of Commissioners changes the ordinance. So this language, you'll see in a second here, is tracking the proposed language to the Board of Commissioners. And of course, if they don't adopt this language, then you may want to think about the implications for you with regard to your rules on language that may or may not be adopted by the Board of Commissioners.
Well, in terms of tracking, I might suggest that in addition to the paragraphs that you have, you consider adding one that would deal with concept review, which then would track the code changes that we may be recommending to the Board of Commissioners.
Okay, so where are we? It sounds like there's at least a suggestion that we perhaps might want to look at some different or some amended language. I think this is a very important topic, one that we do need to resolve, but if, Council, do you think you might be able to incorporate what you've heard here today?
Yes.
Okay.
Just a point of information, we might be able to, however, I mean, as Mr. Mehta pointed out, there's several options in here as to different points. We might be able to reach agreement as to the other points at which there's an option to go one way or the other. And, you know, see how far we get on that, so that when, you know, a revised version of 14 comes back to us, we can, you know, narrow the discussion, if people want to do that.
All right, is there a thought about adopting section 14 as originally drafted, or adopting it with the italicized language added? And that's a broader inclusion of what other regulations, applicable rules, laws, et cetera. So option 1 is as originally drafted here in red but not italicized print, and option 2 is with the italicized section.
May I offer an option 3?
Yes.
Which would be the Planning Commission shall defer.
Right.
Then strike the shall have the discretion to defer. And then accept the italicized language that follows.
I agree with that.
I support that.
That's even better.
Was that a motion?
I so moved.
Second.
Is there a second?
Second.
All right, all in favor?
Aye.
Aye.
And just to be clear, in addition to adding the parallel language for concept review, I'm also to come up with language that Ms. Gay proposed for something a matter that comes up during preliminary review. Is that correct?
Right.
It basically just says it can be deferred at any point during.
I was going to say, is it only during preliminary review, or is it at any stage?
I guess at any stage, right?
That's what I would
Before,
think.
If you see some variance is needed, then it's needed. I mean, or then it, yeah.
And you know, the only additional change you might need to make to paragraph 14 is just to add concept review to preliminary review and final approval. And without making a concept review a separate paragraph, it's just all 3 stages and steps in the process.
Yeah, as long as we can do it at any point during the process,
So,
it's fine.
I will simply add an observation. I don't vote, I'll just add an observation. Just last month, you all had a project concept review for 1 Rehoboth Avenue, where the applicant was very clear that they were going to seek a variance. Whether you want to foreclose a project concept review discussion or have the discretion not to do it and have a very informal discussion at the project concept stage, it's up to you, but you may want to consider having that just latitude.
That's a fair point.
So where are we?
I share the concern that Mr. Mehta just raised, and so I would actually not want to have concept review added to this principle, because I do think there's a value in having an informal concept review along the lines that we had with last month with the one Rehoboth applicant.
Yes.
I withdraw my suggestion.
Would we like to approve where we are up through section 14? I think we had an amendment to section 13, and now we're talking about up through 14, except for we're going to carve out from this approval the language that Mr. Mehta is to draft about the ability of the Planning Commission to actually defer the proceeding once a preliminary site review or other proceeding has begun. I think that's what I've heard. Is that right?
I move. I so move.
Second?
Second.
Any discussion? All in favor?
Aye.
Aye.
All opposed? Mr. Mehta, section
Okay,
15.
then the final few changes, I think will not necessarily require as much discussion, and they'll be done with the rules. Paragraph, section 16, this goes again to the point we talked about before. The Planning Commission shall issue a written resolution or other appropriate document setting forth its decision, findings, and conditions on all applications considered by the Planning Commission after a vote by the members on any such application. Again, given the prior language is a written opinion, I think you want to have the latitude to document your decision in any appropriate document, resolution or other appropriate document. That's the proposal there. And then the final two we've talked about, well, we've not talked about, striking the old paragraph 14. It's, in my view, it's unnecessary to have this in there because the code already states this very language for appeals from the Planning Commission to the Board of Commissioners, so there's no reason in my mind to have it here. It's up to you. 15, we talked about this before. This is the current conflict of interest language, which I would submit fights with and is different than the state code of conduct. The proposal there is to strike that in lieu of the language that I believe you just approved with regard to the bylaws, specifically referring to the state code of conduct standard. And the other changes, I think the change to 17 is just adding that attendance, if a member knows that he or she will not be able to attend a scheduled meeting, to notify not only the recording secretary, but also the chairperson. And then under amendments to the rules, currently the rules may be amended with 5 days' notice, and the proposal here is to say 10 days' notice for an amendment.
Any thoughts about this? These seem fair. Do I have a motion to approve?
So moved.
Second?
Second.
All in favor? Any?
Aye.
All opposed? All right. For the city code, Mr.
Okay. Oops, sorry about that. So now, again, let me, as I did before, just provide some context to this matter. Several months ago, during a June 28, 2022 public meeting of the Board of Commissioners, there was considerable discussion regarding a building permit issued by the building inspector regarding work on the Sandcastle Hotel without review and approval of a site plan by the Rehoboth Beach Planning Commission. I'm not making judgments one way or the other. That's simply the context in which this matter has come up. During an August 8, 2022 public meeting of the Board of Commissioners, the topic came up again, this time in the context of a specific agenda item, review efficacy of City Code Section 23630. The Board of Commissioners determined on August 8 to refer the substance of that agenda item to the Planning Commission. And the mayor asked the Planning Commission to conduct a review of Section 23630 to focus on 236A for clarity of intent and efficacy. At a recent Planning Commission public meeting, this body specifically asked me to draft some language for your consideration. Again, this is for your consideration, but ultimately it's for the Board of Commissioners' consideration. All you're doing is responding to a referral from the Board of Commissioners making a recommendation to them upon the referral for their consideration. They're the ones who modify or amend the code. And my role here, again, like with the rules and with the bylaws, is simply to facilitate a discussion, to help with the drafting, and provide some context to the proposed changes. Again, like I did before getting to the specific language, I will take the liberty to provide just a little bit of context. Let's see if I can pull up this might test my skills, but I'm going to try to show the current language and then the proposed language. So give me 1 second here. Okay. I've been a lawyer for a long time. I've certainly seen a lot of contracts and ordinances and statutes and so on and so forth, and sometimes language can always be improved upon to make it easier to understand and follow. And you may determine that the way that 23630A is currently drafted is a bit cumbersome. The suggestion here is to collapse the two phrases in 23630A into a shorter single sentence and then followed by a separate sentence that introduces the ensuing paragraphs where site plan review by the Planning Commission would be required, and then have a separate carve-out section later. So the first, you'll see when we get to the language, there's a proposal to redraft the preamble simply to make it easier to comprehend. Second, the referral here was to add clarity and guidance. There are some terms in 23630 that are not otherwise defined in 23630, such as development, substantial renovation, increase in intensity of usage. Those terms are used in the existing language. To add clarity, you may want to try to define or make cross-reference to other sections of the code which define those terms. Moreover, there is a specific action item coming out of the CDP that was approved to address site plan review of oceanfront parcels of land, commercial oceanfront parcels of land. You'll see again, in 23630A, there's reference to dwelling units. There's no specific reference to hotel or motels. And again, given the context in which this matter has come up, there should be, or you may want to consider clarifying whether hotel or motels, 4 or more hotel or motel units should be included in this portion of 23630. In addition, as we talked about before, you'll see there's reference in the existing language of 23630A using phrases like substantial renovation and increased intensity of usage without any definitions. The existing language 23630A4 would require site plan review of a project that individually or collectively involves a development requiring a change in zoning. And you may want to consider, given the sequencing discussion that we just had, whether that language is still necessary. Again, I'll get into all of this in the specific red lines. I'm just providing some context to it. Again, the CDP requires a specific provision for site plan review of oceanfront commercial properties. And then finally, you'll see there's this language at the end of the existing language, A5. Any other site plan referred to the Planning Commission by the building inspector until a site plan has been reviewed and finally approved for by the project, by the Planning Commission. And this has been a topic of public discussion at prior public meetings of this body, is the extent to which, regardless of what this language of the statute provides in terms of mandatory site plan review by the Planning Commission, whether the building inspector should have the discretion to send matters to this Planning Commission in his or her discretion, even if not otherwise required by A1 through 4. Okay, so that's the context, so let's go back and look at the proposed language. So you'll see there's quite a bit of proposed new language here, starting with proposed new definitions that otherwise do not expressly exist in Chapter 236. So the proposal here is to add 4 new definitions, one of which already does exist in another section of the code, such as a cross-reference. Development. Proposal is to add a new definition of development for 236. For purposes of this Chapter 236, the term development shall have the same meaning as defined in Section 159(3) of the City Code. And if I can do this, I will show you what that definition is. Quite broad, if that's a definition that you want to use. Development, even though it's not perhaps language for 2022, but any human-made change to improved or unimproved real estate, including but not limited to buildings or other structures, placement of manufactured homes, mining, dredging, filling, grading, paving, excavation, or drilling operations or storage of equipment or materials. I suppose you could come up with a different definition for development for Chapter 236 purposes. I actually think your code already has that somewhat strange phenomenon where the same word is defined differently in different chapters of the code, which personally I would recommend against. I think that is not a good idea, but I don't vote. So that's why the simpler approach here would simply be to adopt, warts and all, the current definition of development. So that's the proposal, and I don't know how you want to go. You want to go through all this, how you want to approach it, if you want to do each proposal on its own, or each, maybe go through all the definitions first, or how you want to do this.
Let's do that.
All right, let's go back to that's the first definition. Again, there's no magic here, but increased intensity and usage and substantial renovation are not. These are phrases that are currently exist in 23630A, but are nowhere defined. So to add clarity of intent, the attempt here is to provide such definitions, but this is just a proposal. Increase in intensity of usage would be defined as follows. A project in a commercial district that involves a change from a use permitted in a lower tier to use permitted in a higher tier. That's would be the basic definition, regardless of whether it also involves a change in the footprint, gross floor area, height, or lot coverage of the existing development, as those terms are or may be used or defined in Chapter 270 of the City Code. Specifically, gross floor area, height, and lot coverage are defined in Chapter 270. So that would be a proposed way of defining increased intensity of usage, the relevance of which we'll get to, when we talk about 23630A.
Luke?
Yes.
There is a substantial improvement clause in 159-3.
Yes.
Definition.
Yes.
It relates to damaged property, but, I mean, is it possible that the definitions that apply to the whole code would be in the first chapter or something?
Yeah, so I thought about that when drafting this, and I think that is a good idea to look to that definition. It's in the section having to do, I think, with, as you said, with flood damage, particularly with regard to towers. What may be most relevant is the substantial piece in terms of the percentage.
Yeah.
I think I'll show you, but I think it's anywhere
50.
between 10 and, is it 50?
It's 50 in this one, yeah.
Yes, 50 here, but I think in other sections it's anywhere between 10 and 25. I don't think there's any magic to it. Again, all that we are really talking about here, and every town, every city does do it differently, I guarantee you, is to what extent are you recommending to the Board of Commissioners, and to what extent is the Board of Commissioners ultimately going to enact an ordinance that says there are some projects that don't need to come to this body for site plan review, because there are certain material size and some projects that do. And the only effort here is to draw a rational line. And whether it's 10, 25, or 50 is completely up to you. I do not have any guidance on that, other than other sections of the code, which is a fair point and one that
What the one you mentioned for context, because I wasn't on the commission yet, the hotel that did not come for review, what was the percentage of the improvement or the renovation relative to the market value of that property? Do we know? I'm just trying to get a feel for.
Yeah. Yeah, so
Where you draw the
I
line.
think, I don't, there are other people in this room who probably could answer that question more factually than I could, but I don't think that that project involved or would have met this definition of substantial renovation,
Because it wasn't an increase.
because it was a facade change and some other.
And the cost of that didn't exceed 50%. Oh, I'm looking at this other one. but
Which
Didn't exceed 25% or 50% of
the footprint, gross floor area, height, or lot coverage?
This is
No.
not a cost.
This one's
Oh,
not
okay, this
cost.
one's a cost. Got it.
This is not a cost.
Okay,
Yeah, okay.
got it.
And then finally, the other definition, proposed definition, again, this is just coming right out of the CDP, a proposed definition of oceanfront parcel land, the relevance of which, again, we'll see in a second here, would be any parcel of land within the city limits as defined in Section 111 of the City Code that abuts the beach or the boardwalk as defined in Section 98.2 of the City Code. So those are the proposed definitions. If I may suggest, Chair, perhaps we should go through the substantive language before voting on the definitions. It's sort of difficult to vote on the definitions until you see how they're being used.
Does anyone need to stop here and vote, or are we okay to proceed? Please proceed.
So then, let's just focus on the preamble. This, again, this is the suggested rewriting of the preamble to make it easier to understand, with all due respect to the prior drafters. No building permit shall be issued for any project or projects that require site plan review and approval under this chapter until such a site plan has been reviewed and finally approved for such project by the Planning Commission. Next sentence. Projects that require, so that's the basic premise. And then we go on to define, well, okay, what projects are we going to talk about that require site plan review and approval by the Planning Commission? Projects that require site plan review and approval are projects that individually or collectively involve, and here we have the subsections. First subsection, you can see the existing language and the proposed new language. Existing language is 4 or more dwelling units, and the proposed insert is or 4 or more hotel or motel rooms, to make it clear that if there's a project involving such as a hotel or motel of 4 or more hotel or motel rooms, that would be captured by the site plan review. I suspect, I'm going to put this in the passive voice, it could be argued by somebody that the definition of dwelling unit perhaps does not comprise a hotel or motel room. And to address that, you may want to clarify that.
Can I ask a question about that? Because I just thought about this today, and this is maybe nitpicky, but I just want to ask it anyway. I think our code is clear that a hotel is a dwelling and a hotel room is a dwelling unit, but I understand the need to clarify, and I think clarifying is a great thing. I'm wondering about the word "or," though. I'm wondering if instead it should just say in parentheses or something, including hotel or motel rooms, because if you say "or," you almost introduce an ambiguity that it is not a dwelling unit. And so so what we're doing is clarifying rather than adding another category. And I don't want it to be adding another category because I think that category is already there.
What about if we say including but not limited to 4 or more?
That would, yes, something like that. I mean, do you see what I mean, Julie? You think you're
I think
shaking
you're
your-
right.
Yeah, so I just don't want to introduce it so that somebody could say, you see, it's not a dwelling because this says "or" and as hotel separately, so.
So in my view, this type of transparent discussion is a good thing for a public body. Not a bad thing. So, I understand what you're saying.
Yeah,
I might suggest alternate language, but I don't have that alternate language.
okay. And if you want, I mean, if the commissioner should also adopt a better definition for dwelling or dwelling, that would be fine too. So I just didn't want to introduce something to the word or, again, it may be too nitpicky, that's why I'm asking as a
Or you could
question.
simply say 4 or more dwelling units, hotel rooms or motel rooms.
Well, again, that implies that they're not dwelling units. I like Mike's suggestion of including but not limited to.
Okay. A2, the existing language is that collectively or individually or collectively involve the development or redevelopment of a parcel of land in excess of 20,000 square feet. Actually, I apologize. The existing language is, on your current code, the development or redevelopment of a parcel of land or adjacent parcel of land in excess of 20,000 square feet. The proposal here is that the added phrase or adjacent parcel of land doesn't really add anything, and to strike it. A3, the existing language is a commercial project over 15,000 square feet of gross floor area or substantial renovation or increase in intensity of usage. The proposed new language read in toto is a commercial project either A, comprising over 15,000 square feet of gross floor area, or B, requiring substantial renovation or increase in intensity of usage, as those terms are now defined in the proposed definitions. Alternatively, you could also consider, and that's why it's included in italicized format, or C, constituting a new building. Building, by the way, is defined more narrowly than structure in your code. I think that's, one of you has pointed this out, and I think it's a very important point. So let me just so everybody, again, my view is transparency is a good thing. So let's just be very clear about this. In your zoning code, under definitions, there's a definition for building and there's a definition for structure. Here's building. A structure, therefore sub-building, a building is a subsection of structure. Building is a structure usually roofed, walled, and built for permanent use as for a dwelling or for commercial purposes. Structure, you will see, is much, much broader, quite broad actually. Structure, anything constructed or erected. Now, by the way, my understanding is that the Board of Commissioners may be coming up with another definition for structure, perhaps in this context or another, so maybe this language will be changed, I don't know. But it's currently worded, structure is anything constructed or erected, including any part thereof, the use of which requires permanent location on the ground or attachment to something having a permanent location on the ground, including, but without limiting the generality of the foregoing, house trailers, mobile homes, relocatable homes, signs, swimming pool pumps, filters and equipment, porches, balconies, decks, canopies, fences, pergolas, gazebos, heating, ventilating, and you get the idea. Structure is quite broad. Query whether, for purposes of site plan review, you want to be focusing on structures or buildings. So in 3, if you're going to consider another trigger for site plan review, which is in the italicized language C, or constituting a new building, that's up to you. But you may want to consider, if you're going to consider that building rather than structure. 4, this would be new language coming out of the CDP recommendation, the development, redevelopment, or substantial renovation of an oceanfront parcel of land devoted to commercial use, as defined, as those words are defined now substantial renovation, and oceanfront parcel of land.
Luke, I have a question.
Yes.
If I might. Does parcel of land include building? Should that be made specific, or is that understood in terms of definition of parcel of land? In other words, there may be an existing building. To me,
Well,
it
if
sounds like
you're
an
asking me, it's the development, the development would be the building, and the parcel of land is the real estate on which the building would sit.
Right, and so I'm wondering, development, redevelopment, or renovation, to me, renovation of a parcel of
No,
land.
I understand what you're saying.
Yeah.
I understand. Renovation of a
Of a parcel of land or building.
building, right?
But the building's not in excess of 20,000 square feet, the land is.
No, we're talking about A4 here.
For.
Okay.
This is the
Okay,
CDP.
Okay.
And it
Right,
would
I get
help.
it. Yeah, okay, I get it.
Would it help to pull up that specific? Let me see if I can do that.
Let me ask, Nan, should it be and/or building? Redevelopment of a parcel of land and/or let's say they renovate the building but don't touch the ground.
Yeah, I think that would be more inclusive. I think that's the.
Here's the language from the CDP. On June 28th, the Board of Commissioners approved the 2020 CDP as amended and subject to the governor's approvals, including the joint recommendation that the site plan should be required for, and the only language is for oceanfront commercial buildings. That's the specific language coming out of the CDP for site plan review for oceanfront commercial buildings. That's the specific language, and the question is, how is that going to be captured in 23630?
Well, I think it can be more expansive in 23630. The CDP is somewhat aspirational and as an action item, I'm not sure it's an action item per se, but I don't recollect between that and, but how it appears in the CDP. But in any event, I think the code can be more expansive.
Sure. So, was it parcel or building, is that there?
And or building devoted to commercial use.
Got it. Then let's just get through one more, and then maybe you can take a vote on before we get to some of the other sections. So then again, A5 currently has this discretionary referral language that would allow the building inspector, even if a project doesn't meet the mandatory site plan review provisions of A1 through A4, would give the building inspector discretion to nonetheless refer things otherwise. And here, and again, I apologize because maybe that what I was trying to accomplish here was not that artful, but what I'm trying to suggest here is to consider either proposed 5 or this other language down here, the bracketed, italicized language at the bottom that says if the building inspector determines that. So these are intended to be alternate proposals for your consideration. So the proposed change to current A5 would be as follows. In addition to the mandatory A1 through 4, site plan review would be required for any other project not described in section 23630A1 through 4 above, that is either A, referred to the planning commission by the building inspector in the building inspector's discretion unless the planning commission declines to consider such a discretionary referral, or B, referred to the planning commission by the board of commissioners. That's one way to tackle the discretionary point. Maximum discretion for the building inspector, the opportunity for the planning commission to say, Matt, thanks very much. We don't think so. We don't need to see it. But of course, if the board of commissioner wants the planning commission to consider it, you would. Alternate language would be to take some of that discretion out. And I think at prior public meetings of the Planning Commission, there was discussion about whether the extent to which the building inspector should or doesn't want to have the discretion, but would prefer to have black and white clear language for when it does and does not go to site plan review. So alternate language, which takes much of that discretion away, would be as follows. If the building inspector determines that a project is not subject to section 23630A1 through 4, or that the project is exempt from site plan review under 23633B, which we'll talk about in a second. This should be the carve-out sections. The building inspector shall forward to the Planning Commission a written report setting forth the basis for its determination that site plan review is not required. The Planning Commission shall review the building inspector's report and shall determine whether site plan review is required under 23630A or whether the building inspector may proceed with further disposition, including issuance of a building permit. So this language is alternate language and provides for very little discretion for the building inspector. In contrast, the proposed language of A5 is maximum discretion for the building inspector beyond A1 through 4.
Okay, let's stop at that point and just take a look at what it is we need to vote on at this moment. We made a change on page 1 to 23630A1, including but not limited to 4 more hotel or motel rooms. We made a change to A4, oceanfront parcel of land and/or building devoted to a commercial use. And we have decisions to make on A5 and thereafter down to beginning with 23631D. What's your pleasure here?
We also have to do A3 because there's proposed alternative language for 4.
That's right. That's right.
Can I have a question? I have a question about that. So the new building is not qualified as to size because those things read or. So it would be any commercial building. Okay.
And again, this is just placeholder language. You can amend it however you want to.
So, where do we stand? What's your thoughts? I'm hopeful some folks focused on some and some folks focused on other parts.
Well, we could just start down 236-30A and go 1, 2, 3, 4.
We've already been through.
Because that would then pick up the definitions, the new definitions.
We didn't have any problem with 236-3, did we? The definitions?
Well, I
I
think we
have a
deferred on the
problem with
definitions
236.
until the
Deferred on
context was
Right.
made clear.
Okay.
236A-3, or 3, the or C constituting a new building, which Susan was just raised. That's just, I think, too vague. You don't want to subject, I don't believe, any new building to site plan review without some further definition or standards. But I'm not sure you need any further definitions or standards because if it's a commercial project, new or old, but you're dealing with over 15,000 square feet of gross floor area, or that requires substantial renovation or increase in intensity of usage, and we can look at those definitions. I don't think we need an additional clause in C.
I agree.
I agree. I mean,
That's what I was getting at.
that would encompass any new commercial project. I mean, it's sort of, it's hard to relate to the structure because for a commercial project either, and then you have to fall within one of the buckets, but the third bucket is anything new.
Unless you
that's how I
want
read it.
that to be subject to a site plan review.
Right, right. But it would be a decision that anything new, commercial, no matter how small, or how limited the renovation, would require a site plan review. So I don't understand what the function would be of A and B.
Exactly.
I mean, well, I take that back. it would require, if the building, if it's a brand-new building, you wouldn't have to to satisfy 15,000 square feet or
Right, any new
substantial.
building is
Right,
what
it
it
would just be any new building,
Any new commercial building.
anywhere, any place in the city.
Yeah.
This language is facilitating the very discussion that I think was asked for by the Board of Commissioners. Where do you want to draw the line? When is it material enough? And this, of course, is an extreme, potentially an extreme example. And the question is, where do you want to draw the line?
So in essence, the question is, if a building is new, less than 15,000 square feet, and, well, I guess substantial renovation would be different from new, but a new, small commercial building, would there have to be site plan review? That's the issue,
I think that's right.
correct? Just so we understand.
I mean, on the one hand, saying that it's any building, that makes the building inspector's job pretty straightforward. You gotta have a site plan. And if you take that out, well, then he may have other issues too that he has to decide. Having not heard from Matt, I don't know what his predilection is, but it's, we're here to discuss.
Yeah.
And the Board of Commissioners will ultimately decide.
Mm-hmm.
So is the proposal to strike constituting a new building?
Well, I would.
But if we do that, and I think that's fine, I agree with that, but then does the rest of it say it's basically any commercial project over 15,000 square feet? No matter what level of renovation that project is, but any commercial project
Yeah.
that,
Yes.
that consists of 15,000 square feet or more, despite what's being done to it, comes to site plan review, or the substantial renovation or increase in intensity of usage for one smaller than 15,000.
Right.
Is that the way it is? Okay.
Right.
All right. That's the way I've always read it, so.
Do we have a motion?
What would the motion be, to strike the proposed clause C?
See.
Yes.
If so, I will so move.
Yes.
Second.
All right, moved and seconded. All in favor?
Aye.
All opposed? Okay, Counselor.
I got that. I think you already talked about 4. So then, the big one is, I think, 5, and how you want to approach 5. And you may want to frame your discussion, you may want to, without getting to the itty-bitty language, just talk more about discretion or no discretion as a threshold issue, and then drill down how you want to address it.
Mr. Mandelis, can I perhaps exercise a bit of prerogative, a chair prerogative, and ask you if you could help enlighten us as to how the building inspector sees this particular issue?
So we have, I think, do you want to come up for Matt?
I'm not trying to put Matt on the spot, that's why I'm asking you, Glenn.
Well, we've got several thoughts about this proposal in general, but as it relates to number 5, traditionally, and this has not only been with this building inspector, but former building inspectors have not adored the idea of having discretion to send or not send certain projects. When this ordinance was originally written, I remember the people sitting around the table and we thought it was a good idea that there would be something that would come in and the building inspector would say, it doesn't hit any of these boxes, but doesn't feel right. It's one of those projects that doesn't clearly need to go for site plan review, but you'd say, somebody's gonna ask questions why this isn't good. And that was the intent of that provision. Through time, I've learned that provision has sometimes been used as a sword rather than a shield against the building official. And there's been questions raised, well, you had the discretion, why didn't you send this? And from small projects to larger projects. So in general, and Matt, we can discuss if you want, but in general, we would like the building official's role here to be less discretionary rather than more discretionary. Also, in this section 5, we're not thrilled with the idea that if he rejects something for site plan review, that a report would go to the planning commission, because we see that basically as oversight, whereas he is a creature of the zoning code, and the zoning code does not create oversight by the planning commission for a building official. So if he has to report to the planning commission those items that he didn't send to site plan review, and the planning commission would then have the ability to say, we're overruling him and bringing it to site plan review, that seems inappropriate. Usually decisions of the building inspector are appealed to the Board of Adjustment. I know we're in the site plan review, we're in the subdivision section, and that's not a Board of Adjustment appealable chapter of the code, but it just seems sideways to me that there would be, or to us, that there would be a sort of an oversight provision on the planning commission with regard to what he sends and does not send.
So basically what you're saying, under the current situation, he is damned if he approves it and damned if he doesn't.
Correct. 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 I mean,
How's your workday going, Matt? Okay. Anyone else have any questions for Mr. Mendelis or Matt?
Could this be where you have specific numbers that would seem to take the subjectivity out of it, and that would be a way to solve? And so substantial renovations going to be defined by some percentage. And I guess the one that isn't is increase in intensity of usage. I didn't focus on your definition, but it doesn't have any, any non-subjective criteria to increase.
Different tiers of
Okay.
use.
Before I lose the thought, Glenn, what's your thought about just saying a site plan is required for any new building in the commercial district? That takes all the discretion away, but that may also increase the workload.
Could be potential.
yeah, I mean, I guess the building inspector's view would be that there are some of those minor, smaller buildings that probably don't require site plan review. So certainly would take the discretion out of it for sure. But I don't know whether, on one hand, it increases your workload, it increases the burden on the applicant to go through site plan review, and there's probably some category of commercial projects that aren't really appropriate for site plan review. But as to discretion, it would take discretion completely away from the building official.
Well, again, it could say any new building in excess of X square feet.
Mm-hmm. That's right. That would certainly take the discretion away.
Well, then you get into renovation, and I don't think you mean new building quite limited in that way. I mean the issue that I have, and everyone on the commission, I copied the email that I recently sent to Matt, just in terms of our ability to know, when there is a situation, and as has occurred, when there are proposals or there are applications that do seem to be borderline. And the question is, and I understand that the building inspector, doesn't want to be in this position of being damned if he does and damned if he doesn't, then I think it is appropriate, since it is the planning commission that does site plan review, for the planning commission to be aware of when site plan review has been not required for projects that are substantial. I mean, all of this language is, comes out of a situation like that. I mean, that's the context, frankly, in which we're having the discussion and in which it was referred to us. And so we've got a problem that we've been asked to solve. And to solve it going forward, I think we need to have, some modification of the process, so that there isn't this sort of seeming, black hole into which these situations can disappear. So in the effort to solve the situation, I think it makes sense to understand that, of course, the Planning Commission doesn't supervise the building inspector. I mean, the building inspector's office doesn't work for us, but it is to us that the site plan review responsibility comes if there is a site plan review. And it is certainly to us that people complain in saying, why wasn't there a site plan review? And at a minimum, we ought to know before a building permit is issued whether that decision has been made, and nobody wants to be burdened with decision-making about sheds and, truly minor structures. And in fact, the building commission has, the building inspector's office has forms that, allocate buildings into those categories. So those are not the same categories that are in the code, but they are actually currently operational categories. So I think there is this need for greater transparency and greater communication in terms of whether site plan review is being required or is not being required. Obviously, once a building permit is issued, then it's done. I mean, we're not going to. I don't even know if we have the legal authority to try and stop a building permit. So it's a done deal. And so I think it's important for the community and important for the city government to have, some openness with regard to this. And I think that, the language, the alternative language, we may need to keep working on the alternative language, but I think that's the sense behind it, at least as I understand it.
If I could respond, I understand that the desire here is to get in front of it, but the way the system is set up now is that if a building permit is issued and somebody thinks it's wrongly issued, there's an appellate avenue to the Board of Adjustment, and and I know that sometimes you don't know it until it's already under construction.
Yes.
But think about the reverse side. The reverse side of it is an applicant comes in, asks for a building permit, clearly does not need to go to site plan review for a number of reasons, but he says, I'm sorry, I can't give you a building permit. You're in a 30-day hold at least until the Planning Commission meets again and blesses my decision to not send you to site plan review. So there's a burden put on the applicant too. When it's a clear application that would not require a site plan review, you've just instituted at least a 30-day wait period.
Well, let me just say that I think it requires, as I understand it from what people have told me, typically when a permit request is made, it's not issued immediately. There's a review process that the office goes through, which requires, not much short of, and perhaps sometimes longer than 30 days. And as you pointed out, even though a building permit can be appealed, nobody knows it's been issued. And even from the monthly report that we get, just the way that it's formatted, there are no addresses, there's no link. That's the problem. And I think there are simple, not requiring huge reports or staff time or anything, ways in which that information can be shared so that nobody, neither the building inspector's office nor the planning commission, is in the position of having construction start in a situation in which it appears that a site plan review might have been required.
Do we post building other than at the site? Do we post them on the website?
Yeah, so you just go to the portal and you can access any building permit that you want to look at. It is on the portal.
You don't know it's there. You don't.
How do
What are
you
you
know
looking
about
for? Yeah. How do
Look
you,
by address.
well, how would
if
you
you
know?
see-
You can look. I mean,
Well,
every address.
No,
The addresses
that's a
are
real
not
concern.
on the
No, what
application.
they're asking is how are they notified that something new has gone on the portal?
Right,
And
yeah.
there may be a way that
Yeah.
We could give planning commission members notification, because I think it's a valid concern that if you want to know about them, that you should know about them as soon as they're issued. But I think that we would prefer that the established process of appealing his decision to the Board of Adjustment is what remains in place, so that if you got relatively instantaneous notification that a building permit has issued, you could go onto the portal right away, see it, read it, go look at the property, and file an application with the Board of Adjustment if you think he's made a decision that's not appropriate.
I don't think it's reasonable to expect the members of this commission, or the Board of Adjustment for that matter, to check every day to see whether there's a new building
That's what I'm
permit.
suggesting. I'm suggesting
No,
you get.
but let me just finish. We got a monthly report that has no address for the, for the actions that have been taken. There are no addresses. And so that's one concern. Right now, we are not informed of the addresses that are at issue. You can post them on the website, but nobody knows they're being posted. And if you have to search by address, then, there's no realistic way to search by every single address. So that's one issue. And the other issue is the timing. And I think that if the current process is to appeal the granting of a permit, and that's the only process, then I think we need to look at whether, we ought to have a different process, whether at least there ought to be some kind of informational process that's in place. And what I hope we could do would be to use the online forms and so forth to immediately notify the Planning Commission. Again, you've already got it online. I mean, it's already there in terms of process. It's a one-page form. And so sending that one-page form on a regular basis to the Planning Commission should be pretty close to instantaneous. It's a public document.
Well, and that's what I was suggesting. There may be a way to do that. We would much prefer some sort of a notification process that you actually get a copy of the building permit when it's issued, versus a process by which there's oversight of the building official that his decision could be overruled by this body. So I guess if you ask
just to clarify, I'm sorry, Glenn, I apologize for interrupting you, but I just want to clarify. What I'm talking about is notification of the application for a building permit.
For major commercial projects.
Yes, not for single residences or sheds or, any of the, there are a whole long list, there's a list of categories that the building inspector's office has established for what level of documentation is necessary to get a permit. And, there's a category for single-family homes, there's a category for a new roof, there's a category for all these things. I'm not talking about any of those categories. I'm talking about the one category on the form already that identifies commercial projects or multifamily homes. That's it.
I mean, that obviously is preferable to having the proposed process here, where his decisions are sent to you and this body has the authority to override a decision of the building official. So there may be an opportunity to work within that framework that you're suggesting. Obviously we would have concern that, the decision-making ability is within his office, so I wouldn't want to provide those in advance, again, so that you can second-guess his decisions. But there may be something that we can work within that framework.
Just on that one, Glenn, but as I understand, again, I think this type of transparent discussion, for what it's worth, is a really good thing, because I think it informs not only the recommendation, but I think it's going to inform the Board of Commissioners discussion down the road. So just to drill down on this, so what I'm hearing is, just from a drafting point of view, if I'm going to draft this thing, or you're going to draft something down the road, and I get it that the building inspector prefer not to have the damn if you do, damn if you don't discretion. I get it, but there's got to be some sort of, because catch-all or other avenue for the planning commission to dig in, right? Because that's the basis upon which they came to the planning commission, right? That's what happened this summer. So I don't see what I heard as second-guessing the building inspection determination if it is simply a notice of a building permit application of a certain magnitude and materiality threshold. Because the whole point here of 23630 is a building permit shall not be issued until site plan review is reviewed, or site plan review is made and approved. So the question is, how do we come up with language that's acceptable to you, the developing community, and the public at large, transparently, and the Board of Adjustment, that gives, because you cannot anticipate, I think this is what the summer told us, lawyers drafting language can't anticipate every scenario. So there's got to be a catch-all somewhere. It's another way to get at it. And so how do we, it seems to me, what we're coalescing around is some notion of some notification of building permit applications of a certain magnitude regarding certain projects. And then the question would be, A, how you define the materiality, and then who pulls that up to the planning commission before not after the building permit is issued, but before the building permit is issued.
I'd like to add one comment to that, which is to reinforce the, excuse me, the issue of notice. These are public documents, and the public is basically, in my view, entitled to know what's pending in the building inspector's office. Not if they don't like it and a permit is issued and they could go to the Board of Adjustments, fine. But most of the jurisdictions with which I'm familiar, when a building permit for a certain level of development has been applied for, the property gets posted and notice is mailed to confronting, adjoining, and sometimes neighbors within so many feet of the property itself. I think there's a concern that, so much of what goes on now is sort of a black hole, and that we would really like to get to the bottom of it for transparency purposes, not just for the Planning Commission, not to second guess what the building inspector is doing, but to make the entire process more open and transparent to us, to the Board of Commissioners, to the public, the Board of Adjustments, and the public at large.
We do post the property, of course, when the building permit is issued. I know that that's further down in the process than you'd like. Luke, to your point about a threshold of what he would send to the Planning Commission, I mean, aren't you just trying to go through the exercise a second time of 23630A, where you've gone through the exercise of what actually does go to site plan review? Wouldn't it be a similar exercise just figuring out another? No,
that's my hope. I'm sorry, I didn't want to cut you off.
I just wonder if it's another. It's been so difficult to define in 23630A those four criteria that would send it for site plan review. It seems like a parallel exercise to figure out what's going to go.
Actually, I meant just the opposite of that. Not a parallel, but sort of because we cannot always envision exactly what we're going to happen. Is there another way to give, if the Planning Commission or the chair or whoever gets notice of certain building permit applications of a certain magnitude, then there's a catch-all phrase where the Planning Commission could say, okay, well, if it's a building permit application of a certain magnitude, then we have the option, the Planning Commission has the option to go and grab that. Using a different standard, precisely to use to the opposite here, a different standard than A1 through 4, because it's intended to capture things that are otherwise not captured. If you don't want the discretion, which I get, it gives these folks the discretion to grab something that's not necessarily captured, not because it's mandatory or not mandatory, but we can't always conceive every scenario that's going to come up in the future. That's what I'm trying to get at.
I just a point of information, where is when building permits are issued, where are they posted? What is?
On the portal on the website.
No, the actual property is posted as well, right?
Yes, the actual property has a green placard to let you know that the site is under construction.
And what part of the website do you know?
So there's a document portal. If you go to the front of the website, you click on, you click on
Okay,
Civic
all right,
Web.
The
I know where that
citizen
is.
self-service portal where
Yeah.
it has building and license, building and inspections.
It's not on the landing page. Or,
That's right.
all right, I just wanted to, I just
Because
wanted
it's
to clarify.
complex, I
where
mean,
it's
it's hard to navigate, but it's there. It's
But- Yeah,
I can appreciate the hard to navigate, and I can inform you that building and licensing is looking at their webpage, and we are going to revamp it to make it a little bit more clear and a little bit more concise with information. So we are working on that. Obviously, we know that it's a process that we have to get through IT, through the mayor and commissioners, et cetera. So.
Well, actually, this discussion has been very interesting. Luke, what you just said about capturing other things brings up, just reminds me of a real-world example. So I'm going to, it seems to me that as much as we're trying to clarify, and it's great that we're making the language more specific, but there's still room for interpretation, even in 1 through 4. So here's the real-world example. We had a case a few years ago where there was a parcel that was a little over 20,000 square feet, and it did not come to us. And once the Planning Commission discovered it and talked about it, the reason we were given is, item number 2 here, the development or redevelopment of a parcel of land in excess of 20,000 square feet. Well, that sounds pretty straightforward, right? Any project. Well, but we were told they didn't redevelop the entire parcel. They only redeveloped part of the parcel. That's why it wasn't going to come to us. So that's an interpretation. In my mind, of course, it means, so I'm actually wondering now if we should change 2 to be the development or redevelopment on a parcel of land of at least 20,000 square feet.
Of any portion of a parcel of land.
But at any rate, that example shows there's always room for interpretation. There's always going to be gray areas, even within the criteria.
What I'm hearing is the less discretion he has is what what he's seeking at this point. That if the Planning Commission can make it very clear where the bright lines are, and perhaps by cleaning up exactly what you're talking about. I'm wondering where we are at this point, though. It sounds almost like we're going to have dueling drafts, but we only have one draft so far. We need the other side. And whether we can ask you to submit to us what your thoughts are, what you like to see here.
Well, Chair, I mean, we're giving you some of that now, and really, I do want your recommendation to be your recommendation to the Board of Commissioners, and then they'll chew on it, I'm sure as well. But I agree with Commissioner Gay that there's still some room within 1 through 4. I mean, one of the examples Matt and I have talked about is the 4 or more hotel or motel rooms. You know, if a hotel chooses to do bathroom renovations in 10 rooms, it's going to trigger that requirement. Do you want to be looking at 10 renovations of bathrooms in a hotel under site plan review?
Well, I think
painting
there
or
always
carpeting.
does, I mean, I think that's precisely Susan Gay's point. There's always room for interpretation. There are always questions. And I think what you're hearing from us is that the attempt to eliminate any interpretation is extremely difficult. And the only way to do that is for the rules to get more and more and more micromanaging. And that's a direction, one direction we can go. But I don't think we can anticipate every occurrence. And I think we have a real problem now in city government where various entities are hearing the blowback from situations in which, you know, Susan described a situation from several years ago. A large commercial land, and there was no site plan review because of the interpretation that it was only part of the land. Or we could give you other examples. I mean, I think we all know what the issues are, and we're trying, I've been trying, to come up with a process that is simple, easy, inexpensive, and imposes no burdens on the staff of the Building and Licensing Office. And that, I think, is ideal. But I don't think my own opinion is that there should be a process whereby this body doesn't get appeals from granting permits, but gets information before a permit is granted in a certain categories, because we are the ones who are responsible for site plan review. I mean, the Board of Adjustment is not responsible for site plan review. That's us. And I think we need to have this information.
And my question is, do we need some time to work this out and work out the language so that everybody won't be happy, but at least everybody won't be angry at each other? That's my question. I'm just not sure we're prepared today to give a recommendation.
Yeah, and if I may just weigh in, I think transparency is a good thing. I'll say it again. There's also the timing issue, though. So we could go back to the drawing board and have another public meeting where we get your comments a month from now, or we could just draft something up and shoot it up to the Board of Commissioners, and the Board of Commissioners could hash it out. Do you have a sense, Glenn, as to the urgency of this getting to the Board of Commissioners? Because if it's not urgent, then maybe we ought to continue to have this type of discussion with actual language we can compare and contrast at a future Planning Commission meeting. On the other hand, this has been sitting with us for a while now. Maybe we ought to just get it up and the debate ought to happen at the Board of Commissioners stage.
My problem is I'm not sure we have anything that even we agree on.
Well, there's been a new proposal now. Right. And the question is, do we draft something on our own for consideration at next month, or do we do that in conjunction with something submitted by the building inspector?
I mean, as far as the city commissioners go, I haven't heard any need for you to get something up to them sooner rather than later. I have not heard that expressed. We are, I suppose it's the slower time of the season. You don't have a very heavy commercial load right now.
Well, we could set our own timeline. We could say, listen, give us your best shot. We'll come with our best shot. Let's work it out in January. But something's going up the hall at that point.
At the January meeting.
Or January, I'm sorry. Am I out there on my own, or do you support me on this?
May I ask a question? And this is a question. I think we all got, including Mr. Mendelis and Mr. Janis, the email that Commissioner Hunter sent proposing this process, which we've now discussed for the better part of however many minutes. But is this proposal or is request that Nan made, is this something that needs to be codified as opposed to a change, adopted as a change within the Department of Building and Licensing in terms of how they are going to handle applications for building permits in terms of making them public, certain categories, major categories for notice and information purposes? Does it need to be a code provision, or is this something that the building inspector's department, with, of course, the concurrence of the Board of Commissioners, could do, and as a matter of practice, best practices, as opposed to putting it in the code?
Let's hear what they have to say to that. Glenn, what do you think?
I mean, it's a good question whether it needs to be codified or not. I mean, I still think that we share the concern that if permit applications, even for a limited category, are going to come to this body for review or be noticed to this body before a permit is issued, you would likely be adding additional time to their review and issuance process. They already get beat up in their office as it sits because it takes a while to process applications. So, I mean, I guess partly you would say that could be done concurrently. You'd be getting the notice and they'd be doing their review.
I just don't see it adding time.
Mm-hmm. And providing the notice, I take it, Nan, that would be it. That's the only requirement that we're asking that they meet is when the application comes in, they send a notice to the Planning Commission.
They'd send a copy of the application for the building permit itself, which would have this
Okay.
information on it.
Okay,
Right.
but that's it, that's,
Right,
that's,
none of the backup documentation,
Right.
and nothing subsequent to that. You
nothing
get-
subsequent. But I assume the backup documentation is a matter of public record, where if one were
It is.
interested in seeing the backup documentation, more about the project itself, details and so forth, that information, those plans, specs and so forth, would be available in your
Right.
office.
Well, let us have the opportunity to think about it some. We actually have a standard call with Mr. Mehta that we talk city projects and things that are going on, just so we're all kind of on the same page as what's happening. I don't know when our next one is, but it might be appropriate to follow up on some of this discussion during that meeting as well. And he and I will have an opportunity to discuss your email some additionally and see. I mean, I understand the desire to have the notice and to be informed. It's embarrassing as a member of the Planning Commission to have somebody come up to you and say what's happening over on Second Street and you didn't know what was going on 2nd Street. So we get that, but I you know, I need to be clear with you that I'm trying to avoid his office being burdened in some way by additional oversight that may not be entirely appropriate, given him his role as a creature of the zoning code. So that's kind of where we are, but I think there's probably some things we can do to accommodate your need for information, which is understandable, while still protecting his interests as a chief building officer, zoning
Okay,
officer.
so then should we defer this until the January meeting?
I think, because we're gonna need to.
I think we definitely needed to discuss. Yeah, for sure.
Well, we've come a long way. We're not quite at the end, but have
Well,
we?
I'd recommend that, I think this discussion is helpful. It's up to you. You only have 30 minutes before you may be other items on the, but there are just a couple of other items just to sort of flesh out the proposal that you may want to at least have some contextual reference for, because there's the carve-out piece we haven't talked about, which is really kind of goes to this point, Glenn, and also the definition. So I think before we leave it, we at least just touch on those. Because I actually, at the end of the day, just for 2 seconds here, I think the drafting of this catch-all, come in and get it, is pretty easy to do. And whether the notice to the Planning Commission comes by way of a practice or a code change to me, is irrelevant.
Okay, so what else do we need to look at to move this to the deferment status?
So let's just go to the catch-all. Well, let's go to the catch-all, which is in 233. So the existing 236-33 already has a carve-out for de minimis amendments, and the idea here, which one of the planning commissioners recommended, which I think is an excellent idea. Again, it's just simple drafting. You have sort of, this is what we're going to do. You can never anticipate everything. So you say, well, if I haven't anticipated everything, if it falls into one of these buckets, we affirmatively do not want it. Right? That's the idea. And I think the concept is a really good one. I'm sure the language here that you're going to want to talk about how broad or narrow you want the carve-out to be, and I think there's room for improvement in this language. This is just posited as a discussion point, just as how broad do you want the grab to be, how broad do you want the carve-out to be. And here's the proposed language for 236-33B would be the carve-out, modifying existing language. Minor structures and renovations otherwise subject to this chapter may be exempted from the requirement of site plan review and approval of the Planning Commission and from the procedure for amendments and additions provided. 1, the structure, again, structure is broader than definition, so if this is the carve-out, using structure broadens it. The structure or renovation is accessory to or a renovation of a legally existing structure. 2, the structure is no more than 200, you can pick whatever number you want, 100, 500, 1,000 square feet, whatever, in gross floor area as defined in section 274. 3, the renovation does not increase the height, as that term is defined in 274, of an existing structure. And then you could see either and, or you could say or. If it's and, it makes it very narrow. If it's or, it broadens the carve-out. and/or the renovation does not increase by more of 200, 300, or whatever number you choose, square feet, the footprint, gross floor area, or lot coverage of those terms are defined in section 274 of the existing structure. So conceptually here, we're trying to articulate, having defined affirmatively what does require mandatory site plan review, since we can't necessarily envision everything. What are the carve-outs that you affirmatively do not want? Well, you're talking about the bathrooms in a hotel or whatever you don't want to spend your volunteer time on. That's the concept. Let me go back, and I don't think we have time to discuss that, so I'm just going to, that's conceptually. Let's go back to the definitions, if I may suggest. A3 is a commercial project either comprising over 15,000 square foot of gross floor area or requiring substantial renovation or increase in intensity usage. So again, a commercial project requiring substantial renovation or increase of intensity of usage would be mandatory site plan review. So a commercial project meeting either of these two proposed definitions. That's the way these two things would work together.
But I think there was a question, maybe Susan asked about what are the standards for substantial renovation or increase in intensity of usage?
Yes, and so
Now, there's a
here,
percentage issue.
so here we have so the increase in intensity usage is going from a lower tier use to a higher tier use. I think that's an objective standard. What has not been clarified, it's a placeholder for your all's review, is the percentage of increase to constitute substantial renovation, a project that involves more than a 25 or 50, or you can pick whatever number you want. There's no magic to it. You're simply trying to define a materiality threshold. Increase in the footprint, gross floor area, height, or lot coverage on the existing, I think what you're saying is building rather than structure, as those terms are or may be defined in Chapter 270.
Point of information, I would just make the point that, as I understand it, correct me if this is incorrect, that substantial renovation is not currently defined.
Correct.
And so 25 or 50, I mean, those are suggested, but
Yes.
as you say, it could be anything. Whereas in 236-33B, that is existing language, and so the 200 square feet reference there is the status quo in terms of what the code language is. Is that correct?
Yes, although I think in fairness, this language comes from an amendment to a discretion that this building inspector has with regard to an amendment as opposed to a carve-out for a site plan de novo, if you will. But yes.
Okay, minor structures otherwise subject to this chapter may be exempted. It sounds to me like that applies to 236-30A.
Again, it's the intent here is to draft it in such a way that even if you can't anticipate everything,
That this is the
these are things you definitely do not want to spend your precious time on.
correct, exactly. And I'm just pointing out that there is a status quo
Yes, yes.
amount there.
Can I ask a question about number one? Am I reading it correctly that any renovation, because a building is a structure, right?
Yes.
So any renovation, it says here, the structure or renovation is accessory to or a renovation of a legally existing structure. So any renovation.
No, but you have to remember it's and.
1, 2, 3.
Four.
And.
It has to be
And.
All
okay,
four.
all four have
All
to
four
apply.
have to
Yeah,
be
okay, got
currently
it,
drafted.
okay.
So structure is
right.
broad,
And
but
then
when you add
right.
1, 2, 3, and 4 together, then it's narrow again.
Yep, that's right. Okay.
Okay, now-
Again, as Ms. Hunter points out, the intent here was to create a carve-out based on broadening existing language in 233B.
Yep, and that's good, that's good.
I have one other question associated with this language. I could see a situation in which adding even 200 square feet could put it over, otherwise a requirement, that limits the square footage of a total building. Is there a provision in here that says the renovation could occur and be increased by 200 square feet, provided that it doesn't interfere with any of the other requirements. Is that kind of language necessary?
I think it's a fair point, and I almost hate to say this, but you could almost decide to, God forbid, put a catch-all in the carve-out. But I think to your specific point, I think is a good one.
Yeah.
Can I ask a sort of conceptual question? The difference between the ones that you have to see, big square footage or substantial or whatever that language is, and where you've set the square footage, and then the ones that you do the carve out at the lower end, can't that be met with just lowering the total square footage down? I mean, because the gray area in the middle is all the discretion, and the question is the discretion here or there? And if you tightened it up, you wouldn't need to carve anything out. You just need to lower lower that language in the 30A. I think I'm talking about the right one. So we're saying over 15,000 square feet. Could you just make that number wherever the number is? But the carve-out creates a whole host of other problems,
So,
doesn't it?
in a perfect world, and if I was a perfect draftsperson or whoever was perfect,
With a crystal
A,
ball.
A
right?
and B would come right up to, they would meet
Yes.
perfectly,
And you wouldn't need a B.
right? But I'm not that good. I don't think anybody's that good. So the idea here is to say, we definitely want this stuff.
Right.
We definitely don't want this stuff. There may be stuff in the middle, and that's where you have this catch-all. We're not perfect enough to define exactly what we want and what we don't want. So we're going to define this here and this here, but they don't necessarily meet in a perfect line. There may be there may be space in between, and that's where you have this catch-all. That's the drafting point.
If I could just say two things. One is that I think that articulation between Susan Stewart and Luke is, is an excellent way to describe what I was trying to get at in my proposal, which is to say, here are the things that we absolutely want, and here are the things we absolutely don't want. And in the middle, we want to know about it. And in line with that, if it's okay with my fellow commissioners, I think it would be appropriate, since you all have seen the letter, that I maybe put it in the minutes, just so that it's part of the official public record, because we've all been discussing it. And the other point I want to raise is point of order, I guess, which is that as I read our current rules of procedure that we have not changed, we have to elect officers by December 31st.
That's right. Yes, I was going to have to move this agenda along here because we have two matters that we have to finish today.
Absolutely, yeah, and we do not have to do parking.
I get a list from the mayor's office regularly that says, where are you on these different things? Where is the planning commission? I have to report back. I would love to be able to report back that while we considered this today, we will work on it and hopefully rule on it in January. But the prioritization of the CDP action items is very important to the city because that becomes part of the budget process. And the city is very interested in knowing what the planning commission thinks should be action items that are undertaken so that they can appropriate for those that they want to work on. So we do need to do both of those things. I think the officer thing can be fairly quick. I think we just did like Susan gave for all three offices, and we're done.
Seconded.
But beyond that, we do need to look at the CDP thing, please.
Yeah, we really do, yeah, because you got a report due Monday.
I do have a report due Monday, probably tonight.
Well, you have till the 12th to do it. And I realize you're sort of caught between a rock and a hard place because probably the mayor's going to ask you, what did you do on parking? But I would be the first to suggest that we're just going to defer that till January.
Yes, we are.
Okay, that's fine with me. Absolutely fine with me.
Can we just get the election over with?
All right. Painful as it is. All right, I think, Madam Secretary, do we have nominees for each office? Yes. And we have one for each office, is that correct?
At least one.
Okay, and can you tell us who the nominees are, please?
Chair, Mike Bryan. For vice chair is Ann Hunter and Susan Gay. And for secretary, it's Julie Davis.
Okay, Ms. Hunter?
Yes, I'd like to thank anyone who nominated me for vice chair. I nominated Susan Gay, and I also want to express my thanks to Mike Bryan, who's been just a wonderful colleague with whom to work over the past year. But as I have expressed both to Mike and to Susan, I really feel like I have some overwhelming other commitments in other zones of my life. And Susan Gay is obviously immensely qualified and would be, I think, a wonderful vice chair. So I hope that we can all unanimously elect Susan Gay to be vice chair.
But to be clear, you're not leaving, you're just
No, I'm
doing
not.
other things.
No, I'm not resigning from the commission. No,
Okay, good.
no.
So since we have one nominee for each officership, can we, by acclamation, approve that? Elect those officers? Is that so moved?
That's so moved. I move
I'll
that.
second that.
Yes.
All in favor?
Aye.
Aye.
All opposed? Thank you very much. Now, CDP.
Yes, CDP, okay. I actually had offered to Mike that I would take the, all the rankings that came in and attempt to compile them, which I now wonder why I made that offer, but anyway. Because it was a harder process than I thought, but in doing it purely numerically, there's a top 10 that shakes out. However, what that doesn't get to is a consensus in a single item that may have it lower on the list than the consensus suggests. So because, and let me give an example. So what I did was, and unfortunately we don't have this as a document to share. I mean, I have it. I sent it to you, Mike, but I did send it to Mike. Yeah. So you want me to send it to you, Luke, and then you could.
Why do you keep talking and you send it to me?
Do you have copies of it?
I have it right here in my computer, but I don't have any way to show it. I don't have it printed out.
And I have it on my phone, but again, no way to print it.
Here, here. Okay, wait a minute. Yeah, all right, hold on. So I put that.
I say it came in right before the meeting.
Yeah, it's just because I just got the final ones this morning, and I had offered to Mike to do this, so. Okay.
And I would like to thank everyone for their work. I mean,
Coming through with
it's
an
very
empty
interesting to look over your thoughts. And they really don't diverge that much. And can I also, as background, my understanding is, and Glenn, you may correct me, but my understanding is the Board of Commissioners is actually looking at taking several of these as true action items that will be acted on, but that they're not intending to implement 10 action items this year.
I think that's correct. I think that there are so many things they're working on now and other initiatives that they have going on that I don't think they could even if they wanted to.
Right.
But yeah, that's the intent, is to take at least a chunk of them and try to get them done this year.
Because the next update of the CDP is not due for 5 years.
Right.
So we have to make progress over a 5-year period.
Right.
But we can't make it all in 1 year. Probably don't have the money to make it all in 1 year.
beyond.
Right, that'll be another
my
factor.
end.
Yeah.
Okay, great, okay. While he's loading that, let me tell you something else I discovered in the process. There were a couple of items where it was noted that implementation had begun. Specifically, the adding the oceanfront commercial buildings for site plan review and our procedures. So in my mind, since implementation had already begun, I did not rank those. I chose it as an opportunity to rank everything else that was not already ongoing. But enough people ranked the oceanfront that it actually became number one on our list, on our combined list. So we have to think about that and to whether or not we as a group take that off because it's already going on, or whether we leave it. But going back to what I was talking about with consensus, and I have the raw data here if there's a question about any one of these. But look at C there, that second one, which by group rank was 6. But 4 members ranked at number 1 and 1 member ranked at number 2. So that's the majority right there that thinks it ought to be first or second, but it became 6.
And that's one, though, actually, that we were called out on somewhat, right? Because it was not done as a result of the
Right.
2010 CDP.
Right. And I think that's why I think I put it.
There's a deadline, 18
There's a-
months.
right,
So,
Yeah. And I think the only ones I noted, if you want to scroll down, I noted that one. And then there was another one under land use, D, where there was this consensus issue. Yeah, go down under.
Yeah, those are, D
Yeah,
is
the
farther
land
down.
use is further up, they're right there. Okay, so for land use, which got to be by group number 7, you had 4 members ranking at 4, and 2 ranking at 2, and 2 ranking at 3. So again, it sort of implies that the consensus there is that it should be higher than 7, but somehow it numerically it became 7. Those are the only 2 I made notes on, well, except for the number A. This is another one. The A, the very first one, scroll back up to the very beginning. Because review and adopting the official zoning map, which again is also to correct the errors that are in it now, and because there's time limited. 5 of us ranked that number 1, but on this it came out as 3. Those 3 where it shows the consensus is different from the rank are the only ones where there was this consensus. All the others are sort of all over the place. And so, you know, in that sense, I guess there's only maybe a few to talk about. I don't really know. I don't know what we do with that information. I'm just saying this is what happened as I was numerically trying to do it.
that's helpful, because like 10 people ranked A and C as 1 or 2.
Yeah,
So that's powerful.
yeah, I thought so too, yeah.
Are there any that could be clearly eliminated, that did not make it into the top 10, or that did not make it into the top 10?
Well, it depends on if you take out, because I really should have ranked beyond 10 in case we decided to throw out those that had already begun. Yes, there are several. I mean, the rezoning any commercial uses that have clear impact on residential neighborhoods, how did mixed use not make the top 10? Because it's been talked about so much. Well, it's because people, here are the rankings: 5, 4, 8, 6, 9, 8, 4, 6. So it probably would have been next on the list. I think it would have been next. But because it was 6, 9, 8, you know, it didn't make the cut. And yet we've been talking about it for a long time.
Well, let me just say that, I mean, to just kind of make the record on this, something I said in my additional comments, and really this is more to the public, but as we were writing and adopting, we weren't writing, but as we were adopting the CDP, we didn't adopt these action items in with the intent of doing this kind of ranking.
Yeah.
So the listing, the original listing, one reason that I suggested, just for people's, you know, information, to group them, was the only thing that the listing, the order of the listing correlates to is the order of subtopics within the chapter. So it's a very difficult exercise. I think several of us expressed that difficulty. Had we known that this would be the process we would undertake in order to try and advise the city commission on budgetary priorities, I think we would have done it differently. So it's very difficult to use this method to identify budget priorities.
If I can say, I totally agree with that. I was extremely uncomfortable going through the process of trying to rank it. I think it was very helpful, Nan, you and others who ordered it to some extent, but I could not agree more. I just think the whole process is flawed. What we do about it now, going forward, I don't know. I think Susan's done a good job of picking out a few of the obviously key items, but how we go from here, I'm not sure. It also does not take into account any of the other items in the other chapters, which I think is a big flaw.
I think another aspect of this, to me, when I went through the first time and ranked them, I didn't do 1 to 10. I ranked the items by groups, because to me, reviewing the land use code involves mixed-use zoning, involves considering zoning of commercial properties that adversely affect nearby residential properties. Yep. Form-based zoning is really part of that group in terms if you're going to consider it. And so I had items A and C together as a single project. It's not a question of first versus second. Right. If you're going to, review and update the official zoning map, you have to look at the future land use map in the CDP as part of that process. Same with the parcel-based mapping exercise. I mean, those are all part of a single inquiry. And of course, some of these don't have any budget implications at all. So, it's difficult if that's supposed to be one of the focuses, including oceanfront properties as part of our site plan review projects. I can't see immediately how that adds to or creates a budget issue for the Board of Commissioners in January or any other time. So that's all time, just following on what you're saying, additional difficulties.
But if you take out something like the commercial property site plan review oceanfront property, as it's on, if you take out what's ongoing,
right,
and so that knocks out what was number one that Susan came.
Right.
Then what's the next 5 that aren't ongoing?
The ones that didn't get ranked, didn't make the cut, but aren't ongoing, I believe the mixed use would probably be next. Hold on a minute. 5.6.
The next highest one.
Yeah, the next highest ones would be mixed use and evaluating the benefits and risk of having a parcel-based official zoning map. Those are the next 2. So the very bottom ones, the one that didn't make any cut, was the rezoning any currently permitted commercial uses that have an adverse impact on neighborhoods. That was, and then the form-based codes. Those were the 2 lowest.
But what I'm looking for is, what are the top 5 without what's ongoing?
Oh, well, if you're looking for the top 5 without ongoing, then all you have to do is look at, on this sheet here, 2, 3, 5, 6, and 7.
So if we sent a list that said these are the ones, and we probably can rank those, right?
Well, they already are.
Okay, so we can rank those, and then if our list would include the others that received votes,
So you want to do a 5 instead of a top 10?
a five that's ranked, and a 5 that just says here's the rest. Because we don't have those ranked.
We do. Well, we do. We have 10. We have everything's ranked. I mean, there's even 11 and a 12 if you want. You go that far.
Oh Lord.
They're ranked. They were ranked by somebody.
Okay.
Everybody ranked something.
Okay.
It's just that the 2 that if we wanted to eliminate the 2 that are ongoing,
Right.
and go with and pick the next 10,
Right.
then I think the 2 that would come onto this chart that I don't have on there because I only went to 10 would be the parcel-based and the mixed use.
Okay, so since we know we're giving them more than they are going to act on, for a lot of different reasons, good reasons, can we give them a ranking of 10?
If that's the criteria we want to use, to just go with the top 10 that are not already in the works. But then how do you solve the problem of of A and C being ranked very highly by everyone, but falling out here is 3 and 6? What do you do with that?
I think we go with the methodology we've been given. They're going to make their decision anyway. They wanted to see what our thoughts were, and I think if we share them by saying these, and share
that detail
and share
too.
completely what you have done.
Okay, yeah, all right, fine, okay.
So that they can see how some got weighted and some didn't.
Okay.
Susan,
Does that
did
make
you,
sense?
like, to get a 6, you added up at ones, her 1, my 8, whatever, and then divided by the number of respondents?
Yeah, but I
Okay.
did it both ways, and actually, of course, I should have realized this from the beginning, it's exactly the same rank, whether you do it by total number or by dividing it by 9. If somebody rated more than 1 a 1, because I did that myself.
Yes.
I counted it in each place.
Okay.
Because it's still, there's
did
still 9
too,
of us
like you
voting on that topic. But for instance, on the updating of the zoning map, I think what took it down is 2 people voted at 8 and 5. But the rest of us were 1, 2, 1, 1, 1, 2. So that's how it happened. You know, that's.
You guys support the notion of having her put a ranking together with what we have, telling her,
has,
telling
right?
1 through 10,
Yeah, okay.
but giving them the backup documentation to demonstrate how you arrived at that.
Okay.
And then hopefully from that, they'll see what is at the top of the pile and what's at the bottom of the pile and what's not on the pile.
Okay.
And I can check one more box off my list.
Well, it might be useful, actually. I don't know how much information, they want, or if they're doing it individually, say by individual members of the Board of Commissions. Do they want individual rankings from us? I would suggest giving them Susan's, compilation as you just described it. And then if they want it, give them each person's.
Yeah, but without name, like, should we just do it 1 through 9, or do you want everybody's?
Oh, I think it's,
I
what's,
think you ought to get everybody's, or at least those that have comments.
Okay, okay.
And it's already
In cases
foiable,
the
right?
comments mean more
Yes.
than the ranking.
Give them everything.
it's all public, there's no.
Yeah,
no
I'm,
reason to-
I'm okay with that only if the discomfort that several of us have with the process is also, a part of that package. I think we can't go out of this, I can't go out of it thinking that, we've put our best foot forward and this is what we're giving them.
Well, I think we have, with the methodology just has made it difficult.
Well, okay, but,
So you want the caveats to be in there about that this did not produce an ideal outcome.
exactly.
Okay.
Do I have a motion to approve that?
So moved.
Second?
Second.
All in favor?
Aye.
All against?
Aye.
Thank you. Okay, then we are deferring parking,
I guess we'll have to.
and it's 4:30.
How about that?
We're adjourned.
Susan, you haven't sent that out to us.